with us today, and so I've been asked to serve as a temporary chairman of the committee for today's meeting. My name is Henry Haas. Let me call the roll of those people that are present. Vic Alexander.
Here.
Gay Moon.
Here.
Gabe Roberts.
Here.
The four of us will make up this committee meeting this afternoon. Please excuse me if I act like I don't know what I'm doing, because I don't really know what I'm doing. So we'll figure out our way through this thing. I've got an agenda that was sent out a few days ago for the meeting this afternoon. If everybody's got a copy of that, and I'm going to try to follow that, and then if there's anything additional we need to add to it, I think we can certainly do that. The first item on the agenda is request for firm name approval, and we've had several of those come up. I think we've got them. You've got them on your iPad. One is from Compass East. One is from Integrated CFO. I think we have heard of that firm before. And then we have a new one, Craft CPAs, Turnaround and Restructuring Group. And then we have Pinnacle CPA Professional Services. I'd like to point out that you've got, should have in your papers in front of you a document about 20 pages long called White Paper CPA Firm Names. Everybody got a copy of that, or everybody find that in your papers? Mark, do we know where did this come from?
That was generated by NASBA and the AICPA. I believe this is a NASBA product.
So who found it?
Josh found it for us.
Oh, great. Okay.
So it was put out in August 2009. I believe we circulated at that time, but that's been 6 years almost. So
Right.
maybe it's time to review it again.
Well, considering the frustrations we've had over this whole issue, I think certainly it's do we know if there's been any kind of further consideration, further update, or further study done beyond this particular white paper?
Not that I could find.
Okay.
No, sir.
Chairman, you also have a summary of what we found for the surrounding states as far as fictitious names goes in regard to their law and rules. That should be the one that begins Arkansas.
That would,
It really is all across the board. And it seems like everyone is looking at it on a case-by-case basis.
I would, we could get into a lot of discussion this afternoon on this, but I think what I would suggest that we do is that we table consideration of these requests at this meeting today. Maybe recommend it to the board tomorrow that we table it. Give us all an opportunity to review these documents and see what they really say and what they mean. And come back to our April meeting and bring it back up.
Mr. Chairman, there is one item here, and Mr. Alexander's going to have to recuse himself for from voting on it, the Craft Restructuring and Turnaround Group. We brought this to your attention because at first there was a disagreement between the firm permit coordinator and the executive director on whether or not we should approve that particular firm name. we have since come to the conclusion that we probably should go ahead and approve that one. It doesn't seem to be misleading. So I would ask that you vote to approve that one if you would. And I know that Mr. Fault will be here tomorrow to talk about integrated CFO. I don't think Mr. Neville's going to show up, but I think he'll be here to present his view of things.
For the record, I will recuse myself from any of that discussion.
I'd also say, Mr. Chairman, for the record, that for Compass East, I'm going to have to recuse myself from that discussion. I know we may not get into it today, but to the extent that it ever could be said we looked at it today, I just want to be on the record as saying that.
Let's consider the request by craft CPAs then at this time. And opening this up and looking at the very first page, item number 3, Karen, I'm a little confused over the word "no" that's in there. What does that mean? Firm name approved. Are you saying no, that it's not approved?
Yes, sir. It requires my approval and Mark's, and just looking at the rule that says the name of the firm can't have more than one fictitious name, I didn't feel that I could approve it, but Mark and I have talked about it since, and we both feel it's okay.
What's this? Okay, number 4 says experience approved CPA license verified for each CPA supervisor. The word "no" is in there also. What is that? You got the same thing in number 5. The word "no" just kind of confused me a little bit. Very first page.
I think maybe because the experience in that area wasn't required because the firm had marked no reports and they're not doing a test services.
I think you've got, then you've got CPA and non-CPA ownership approved. I noticed that there's 2 individuals, both of them are licensed CPAs, and then there's the firm ownership. Is the firm part of the ownership, what you're saying there? That's a no?
Yes, sir.
Okay.
But on reconsidering that, we do have a list of firm owners for craft CPAs, so we do have that elsewhere.
Right, okay.
And also, just to clarify, Henry, the rules say that they must be, owners must be licensed in this state, and craft CPAs is licensed. So they are a licensee, so they do qualify under the statute as an owner.
Comments, discussion?
It's just a renaming. This is a renaming of an existing entity. Asking for a change of name, or is this a whole new entity?
This is a whole new entity.
I don't see any reason why we can't move forward on this particular request and approve it. I don't see anything fictitious about craft CPAs. Even though it says turnaround restructuring group, pretty well defines what it is they're going to be doing.
Chairman, I would agree with that. I mean, to me, it seems like this is something that we actually know and can understand when we read the name, which is, I think, some of the things we've run into in the past where we didn't quite understand the words used, or perhaps it was a made-up word or something to that extent.
Could we get a motion to recommend this to the board tomorrow?
Sure, so moved.
Okay.
Second.
Other discussion? If not, all in favor say aye.
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 All opposed, motion passes. Okay. The rest of these.
Hey, Henry, just a quick question, and maybe Mark could help with this a little bit. How's that going to play tomorrow when we have an audience of some other people requesting name changes and we pass this one? Because that's got to be recommended to the board, I assume,
It
tomorrow?
does have to be recommended to the board, but I think you've got a strong case here because you
Because
do
the
have.
CPA's name is in it.
Yes, the
Yeah.
CPA's name's in it, and it's very clear as to what they're doing.
We just need to be clear about that tomorrow,
Yes, sir.
I think, when we do that.
Next item on the agenda is review of CPA applications. This Becky Gray that we're talking about?
Yes, you actually have several to consider there, Henry. Becky Gray is one of the first ones.
Is the waiver, the request for waivers also part of that request, part of that?
He's
I've got
requesting-
Eric Mathis, Judith Clark, Suzanne Allman.
I think they're all 10-year outside, right? Or weren't most of these all?
Right, that's all 10-year.
Yes.
Is that part of,
Mr. Mathis is a whole different matter, but the others are the 10-year rule.
on the agenda, we've got review of CPA applications. Is that part of that? Okay. So Becky Gray would be our first one. She's requesting additional time to complete the ethics exam.
She's actually completed the ethics exam at this point, Henry. I got an email today from her. But here again, she is outside the 10-year rule as far as her first passing grade on her CPA exam. And that's what she's asking for a waiver on.
Parker, didn't we last board meeting, didn't we have a similar issue with someone outside the 10-year period? Is that, my memory correct on that?
We've dealt with it in the last two, for sure. I
Yes.
thought I was here for one.
Yeah, it's come up several times now, Gabe, since that rule went into effect.
Haven't we generally granted the waiver?
Yes, generally you have, unless there was just no good reason for not having been licensed. But in this case, the lady was taking care of someone who was ill, and then it led to some health issues of her own. I would recommend that you grant the waiver.
This particular individual, we haven't had anything filed, any complaints filed or anything like that. Okay.
Don't we
Move that
run into some, I'm sorry, go ahead, Vic.
After you, I apologize.
Don't we run into some issues with these folks as far as the hourly requirements? As far as
Or
having
two.
the number of hours to, because all that changed. Would that have been in place 10 years ago?
No, but in this case, she has completed 150
She did,
semester hours.
okay, I think I remember reading that, okay.
Yeah.
Make a motion that we grant her a waiver of the 10-year provision.
I'll second that.
Any discussion on that issue, on that motion? If not, all in favor of the motion, say aye.
Aye.
All opposed, motion passes. Okay. Eric Mathis,
If you don't mind, can we leave him till last, Mr. Chairman? He's going to be a little bit more complicated.
okay. Judith Clark,
Here again, in this case, Ms. Clark took time out to raise her family. She did continue to work some in the accounting field. Management's recommendation is to grant the waiver. And once again, she does have the sufficient semester hours to meet the education requirement. We cannot license them unless they have 150 hours.
I assume she's passed the ethics exam and everything?
I'm not sure she's passed ethics yet, but that's one of those things where you order it, you do it, and then you send us the grade.
Have any comments? Can we have a motion to approve or disapprove?
So moved.
Approve or
To
disapprove?
approve. I'm sorry, to
To
approve. Sorry.
Okay.
Second.
Second. We have a motion to approve and a second. Is there any further discussion? If not, all in favor say aye.
Aye.
All opposed, motion passes. Suzanne Allman.
Game management would recommend that we approve this waiver. Ms. Allman clearly specified that she had respect for the profession. She did not feel that she could uphold a professional career and raise her children at the same time, so she delayed getting a license until her children were a little bit older. Challenging child, I'm not exactly sure what that means. I mean, I have one that was challenging too, but on the other,
I've got 3.
but could be for completely different reasons. But, you know, I would recommend that you grant the waiver for her.
Make a motion that we grant Ms. Almond's waiver.
Second.
We have a motion and a second. Is there any discussion? Is there more than one page to that? I've only got one page.
Here
Oh,
are-
no, I see. I got,
Yeah,
I
you
got
should
it
have
here.
more than that.
I just didn't push it the right way. Okay, we have a motion and a second. Is there any further discussion? If not, all in favor of the motion, say aye.
Aye.
Motion, is there, all opposed? Motion passes. All right. Is there anybody else other than Eric Mathis that we need to cover?
If you will look at Stephen Russell, and that may be a little bit farther down the agenda, but let's go ahead and look at him while we're looking at applications. Mr. Russell is requesting that we consider a course called Law and Accounting that he took in his second year of law school as upper division accounting course to meet the 30-hour requirement. I initially denied this based on my review of the course that he sent in, and what I'm going to point you to is if you've pulled him up and you'll look on the second page, the very last sentence says, "The course assumes no background in accounting." And I don't think that we can give upper division accounting course for a course that doesn't assume any background in accounting. That sounds to me like an introductory course. 2 hours short. I feel for the guy, but I just don't think that we can grant this.
Did he have principals class in undergraduate that he's counting as well?
Pretty much a standard course in law school, though, isn't it? Don't they have to take something like this?
Well, in my experience, it is if you want some type of business, or at least where I went to law school, it was where if you wanted some type of business emphasis. Again, I'm not sure how this relates. I think it looks like I went to Memphis for law school, but at Vanderbilt you did it, and it was basically a combination of a principal's intro 201 type class, along with some legal piece brought into it as well. In fact, I didn't take it because I had taken Intro to Accounting as an undergraduate.
Mark, you're,
Y'all have
Manager.
y'all have an educator here from the university on the board if you'd like to.
Are you against? Against granting it? Okay. That was my position.
I was just going to clarify.
I hate to be at odds with the educator on the board.
I mean, the position is that it's an introductory class, it's not an advanced class. Is that the position of management?
Yes, that is management's position.
And it sounds like, based on what Mr. Roberts said and what we expect Charlene to say, that's going to be the case. Okay. I just want to clarify.
And please understand that if he was trying to get this as a principal's course or as lower division credits, I'd be more than happy to give him the credit for it. But he's trying to claim upper division, and I just don't think it qualifies.
And I guess one,
That's a distinction you're making between lower and upper, right?
Yes, and that's the distinction that's made in our rule. It is rule that you've got to have at least 24 hours in upper division courses in accounting in order to qualify to sit for the exam.
That's where he's short.
That's where he's short.
and I probably should know this, but is there a definition of what upper division courses is in the regulation?
It is. Where's my rule book? It is. Here we go. So speaks the educator. Yeah, Rule 0020-02-.02, and this is number 3. It says, for purposes of this rule, candidates must have at least 24 semester or 30, and this is the old rule, it's now 30 hours of accounting courses at the upper division level. Junior level courses are higher. That's how we define it.
So the fact that it was taken in a law school, which is postgraduate, does not really matter.
Okay, the problem here again is it is an introductory course in law school. It is a junior level course in law school, I think, but it assumes no background in accounting. So to me, that indicates a principal's course.
Plus, we don't count law.
I did not realize that the business law class I took would not have counted. Okay.
Is that a university policy, or is that a? Okay.
Okay, where are we? What did?
We need a motion.
What would be your recommendation for the board tomorrow?
Our recommendation is to deny him, deny the credit as upper division courses.
Asking the board.
Oh, I'm sorry. Yeah, I thought I heard my name.
No, that's fine, that's fine, that's fine.
I make a motion that we deny the specific request.
Okay. Do we have a second?
A second.
All right. Any further discussion? All in favor of the motion, say aye.
All right.
Aye.
All opposed? Motion passes. Okay.
Can he not sit within a certain period of graduating? What is the rule on when you can actually sit? You don't have to actually have all the hours, right?
No, you don't have to have the hours. You have to have a certificate.
My question is this person actually harmed? If he can prove enrollment, he can sit for the exam, correct?
All he has to do is say he's gonna take the 2 hours within 150 days.
Passing the first part?
Right.
Okay.
If you pass it in February, you have to complete the hours.
I guess I'm trying to understand the frustration. I mean, I know he don't want to take another class. That's frustrating enough, but he can sit for the exam, I believe. So I don't know if we've communicated that to him or if he knows that or,
I will.
okay.
All right. Discussion about state-specific ethics?
Can we go back to Mr. Mathis now?
Yes, I'm sorry. Yes, go right ahead.
Y'all read the file on Mr. Mathis?
I ran my printer out of ink yesterday.
I guess my question is, do you have any questions about the information you've been given?
We opened an investigation or filed a complaint.
Actually, Mr. Watkins, I asked our previous legal counsel about that before his departure, and he said our best avenue here is to deny the application and then see. I will tell you that I expect Mr. Mathis to be here tomorrow. I've spoken with his attorney. He's represented by Rowan Leathers. Mr. Leathers and I chatted Monday afternoon. I gave Mr. Leathers some information that he did not have access to, and he told me that he would recommend to his client that he come tomorrow and make his case before the board. So, if you review that information, you have any questions, you can ask me today, and I'll give you my opinion, but he should be here tomorrow.
Was there a discussion with his attorney about the use of CPA and?
There was, and the attorney indicated that he knew that there was the use of the CPA on the email address. He was unaware of the other issues. So that's when he said, I'll recommend to my client that he be there tomorrow, that he be there on Friday to explain himself.
You gonna be represented by Roland?
I'm not sure Rowan's going to be here. I think he's going to send his client by himself.
Well, I would.
I was hoping the meeting tomorrow would get over early, but if Roland's coming, it may take a while. Go ahead.
No, not that I know of. No, that's Mr. Lloyd from the comptroller's office. And you can table it for consideration by the full board, or you can go ahead and make a recommendation. It's whatever the committee decides. Management's recommendation would be to deny the application.
This is about as bad as it gets.
In my opinion, yes.
Never anything quite like that.
If we recommend to deny it to the board, but he's here tomorrow and have questions, et cetera, I mean, are we denying him the opportunity to be available for questions, or are we okay with that? I mean, we can change our recommendation to the extent anybody thinks we should after speaking
The
with him.
committee just has the unlimited power to suggest and recommend.
Right.
The ultimate decision would be with the board.
Right. Okay. So we're not messing him up if we go ahead and not table this today.
No.
Okay.
I mean, the committee can make the recommendation, then Mr. Mathis can present his case, and the board can certainly make a decision to approve the application at that point if they want to. Gabe, is that correct? My attorney, just to be sure.
I'm quite amazed he wants to come and speak after seeing this.
And he may not be here, Trey.
Yeah.
I mean, I just know that Rowan told me he would recommend to his client that he come.
You haven't received a confirmation from him necessarily that he's coming. Okay.
Have we talked to the ladies that have sent emails? I mean, I was pretty floored at the accusations that were made in those emails. I mean, is that the only communication we have had from the previous employers, or?
Josh, I'll let you address that,
Okay.
since I believe you've spoken with them.
Kind of the history of how this developed was Miss Royalty signed his experience on his application. She contacted me on the phone, said she wanted to retract that, and then asked me, and I just told her the complaint process and what she could do, and she chose to write that email. She never filled out the formal complaint form, but she did send me that email. And then I worked with Mr. Whitaker, our former attorney, how to best approach the matter. And we decided it'd be best to let the board see it and decide on it, as opposed to do anything immediately.
Other questions? We want to make a recommendation to the board on this for tomorrow?
Yeah, you want to say something, I can see it.
No.
I think, I'll be honest with you, I think we ought to make a recommendation one way or the other, and then the board can decide what they'd like to do. But from our committee, we probably ought to make a recommendation on it. If this person had passed the exam parts within the 10-year period, would they be allowed to get a license?
There's a
Considering
felony.
all of the background information?
Well, with the felony conviction on the record, that's still something that the board has to look at and consider, because our moral character clause does include a statement that good moral character for holding a CPA license includes a lack of a history of dishonest or felonious acts. And
If we let him out of the 10-year requirement, then we've still got to go back and consider it based on the felony conviction.
Yes. And then you've got to consider the more egregious acts that have happened more recently, the use of the CPA designation on his mail and his resume, and
We got 3 different issues here, or we're really considering the first, but
right, you've got a whole plethora of problems.
He's currently holding himself out as a CPA in a CPA firm,
He has been, yes. And I believe he indicates on his resume he's a CPA in Kentucky. He was never licensed in Kentucky.
yeah, that's what I'm looking at is his resume, and he's showing that he's got, it says, Eric Mathis, CPA, Louisville, Kentucky, 2007 to present, certified public accountant, and all this stuff that he does for clients.
He's currently employed with Mana International, and from my understanding, it's a construction firm. And for some reason or other, some kind of way, they want to kind of develop into a CPA business as well. And they are here in Tennessee.
Has he applied in Kentucky?
Not to my knowledge, no.
Okay.
We have no record of that. Do we have a motion to come before the chair?
I'd like to have a motion one way or the other if we could.
I move that we deny the request based on, there's a number of things, but most importantly, the fact that he's held himself out as a CPA when he wasn't in fact a CPA. That he's got felony convictions. I think he needs to explain to this board before this board would feel like we're protecting the public.
He's already shown to disdain for our rules, it seems like, if that is in fact his actual resume. So I agree with what y'all are talking about.
He doesn't really offer an excuse about the 10 years or.
I can't remember from reading, I mean, literally, it's this whole stack. Trying to remember what I do recall from that.
I have a letter from Mr. Leathers somewhere in this stack of stuff.
That's what he's asking us to overcome.
He's explaining the 10 years as because of his addictions and because of his incarceration, felony convictions, and all the problems surrounding that. That's why he says he did not sit immediately after graduation and completion of the exam. I'm sorry, did not get licensed immediately after passing the exam.
We have a motion to deny. Is there a second?
Second.
Okay. Any other discussion? All in favor of the motion, say aye.
Aye.
All opposed? Motion passes.
Mark, have y'all looked out on the website or anything where he's working now to see, is there a profile or anything where he's working?
No. I've been in contact with his current employer as well, and they say work. That's as much as I know. He has no internet presence.
Mark, is there anybody else that we need to give consideration to at this point?
No, sir. Now you can move on to the other items on
Question
the
on
agenda.
state-specific ethics?
Yes, sir, please.
Okay. Discussion on audit of CPE sponsors. What are we getting into here, Mark?
Well, I think it all kind of ties into how you want to offer the ethics course in the future. We currently have, Karen, correct me if I'm wrong, but I think we have 18 approved sponsors of the the state-specific ethics course. We have not actually had in place any type of monitoring system for those since that the course was required in 2006. So what we're considering doing as a staff is if we audit 20% of those, that's going to be approximately 4 programs a year or a cycle. We will look at those, pull them in, see what they're offering, make sure it is contemporary, make sure that it is something that we need to have out there. Looking at what we have approved in the past, there have been instances where we have simply had providers that have simply laid the law and the rules out there, said read them, answer these questions, and you're done with the state-specific ethics course. And perhaps we need to take a harder view at that and have a more creative approach into how we're going to offer CPE. The TSCPA is asking to be considered to be our sole provider so that we have one quality course out there that everyone has to see. And the more I think about it, the more I think I'm not opposed to that approach. So I think if we're going to audit CPE sponsors, perhaps now is the time to pull them in, look at them, say you're not doing this and this and this, and this is what we'd like to have done, and start denying their approvals. That's just my opinion. But I think working with the TSCPA, we could offer a really good product, and that way you know everybody's getting the same thing they're learning the same information. This board requires this state-specific ethics course. I think we need to have a better handle on exactly what information we're transmitting.
Once the firm has been authorized to give
Would you be sure you speak into the microphone? And no, the only requirement is that if there are substantial changes to the course, then they must resubmit. But if they're not substantial changes, then no, we have nothing in place to require them to reapply.
Is there anything in the iPad relative to this issue? We got anything on there? I'm just looking if what we're talking about here is all discussion, or if there's really some materials here for us.
Yes, sir. I don't think there is anything on there.
Okay.
Mark, is this electronic? How's this being developed? Or Wendy, you may have some insight on this. I don't know. How are y'all? I mean, y'all may not have gotten into specifics. I agree in principle that we need to have a common voice. I'm just curious the method and fee. I mean, is this a fee for service type thing, or how's this going to be handled?
We actually met with Wendy and Brad
Okay.
This week, and we talked about this a little bit, so I'm going to let Wendy take the TSCPA's
I don't know,
viewpoint.
Trey, were you at the last board meeting?
I missed the last
Okay,
meeting.
so we did come to this board at the last meeting and give a brief proposal on our thoughts behind this. Mark's kind of laid it out, but the idea would be for it to be an on-demand type product that somebody would be able to access 24/7. It would be a product that we, rather than just somebody speaking for 2 hours, we incorporate scenarios, we incorporate some multiple choice questions, try to keep it really engaging and use some of the principles of the future of learning that's kind of in our world now with CPE, and try to really create a product that engages the members, make sure they're up to date on hot button issues, issues that this board is having. We can quickly turn around and make sure those are incorporated in such a course. We feel like it's something that would be good for the licensees to hear the same thing rather than potentially hearing it 18 different ways. And Mark would be involved and be part of the process. And we also propose that once the product is created, the board would see it, approve it, make comments, as well as even fees.
We're already giving away CPE for free in some instances. Was it 20 now?
Yes.
If we have more than 20, the board will come and present. I'm curious, does this pretty well, since it's on demand, is there a need for, I mean, obviously we want to be seen in the public. This is something we've been shooting for a while, was just to go digital with all this and have us delivering the content. I'm just curious what that means for this board and how we travel around and present these courses now.
Well, I think there's still going to be some advantage, and some groups just like a live presentation.
Right.
Trey. And here again, the idea is to get one course and have one message.
Got that.
That
Yep.
gets out there. So yes, there would still be some travel for staff involved in presenting the course, but probably not as much as there is now.
Right.
Because I think the TSCPA is looking at, and correct me if I'm wrong, Wendy, but offering it at a price that makes it advantageous for those people to take it online,
Right.
rather than try to get
Very minimal.
struggling to get a group of 20 together like some of them
Right,
do.
right, right.
It seems like that it would be important for the state board individuals, either Mark or Don or Raymond, to go and to the chapters and visit with the chapters and talk with them a little bit about some of the activities of the board, but not necessarily present an ethics class that would last an hour or 2 hours or whatever length of time you offer it. What's always been very disappointing to me in a lot of those ethics classes is that the substance of the information that you receive is virtually useless. I mean, a lot of that information that, you know, if you really want to talk about ethics, then let's get into some ethics issues. it just seemed like there wasn't very much substance there in the way of ethics issues that was discussed.
We also, I think I brought this up at the last meeting, but it may have been quick. NASBA is working with the Big Four and has been given funding to help create resources for state societies, and I think that's to address some of your thoughts that you just mentioned. So we'd be able to use something like that as well.
Good. Very good. Marcus, your thinking now is that you would just postpone the audit of these sponsors or the sponsors for the time being until we could come to some decision about working with the TSCPA?
I think
Or-
that would be wise. On the
Doesn't
other
seem
hand,
like you're wasting a lot of time if you went ahead with it and we decided to go with the TSCPA.
Yeah, I agree. I mean, you're looking at staff time there because it can be staff intensive when you look at these courses in depth.
Yeah, yeah.
I think it is challenging when you have a company out of California that's trying to provide Tennessee-specific ethics. I mean,
Right. That's
on a
good.
general idea, I think that's probably not the best. I'm not to say they can't do it. It's just that it becomes much more difficult, and I wonder how much more generalized it is than specific.
Yeah, well, they're the companies that just give you the law and the rules and then ask some questions about
Yeah.
it because they're providing ethics for most states.
Right.
So it's, they have a standard format that they.
Real quick question. So I may take a different view. I think it's a great idea for the TSCPA to be a leading ethics CPE issuer, I guess, or tester. But my question would be for the 18 or so that we've already approved. And maybe I thought I said this last week, and so forgive me if I'm repeating myself, but it seems like it might be a better position for us to actually do a quality review of the programs that they're currently doing before we make a decision to end their ability to continue participating in it. I mean, we say that some of them just have the rules and that's all they do, and maybe you all know this because you take the exams. I certainly don't. But I would like for us to actually have some evidence. We've looked at these. Maybe there's a handful that are really good, but maybe there's a good number that aren't very good. But I like to have some type of hard data. or
I
evidence
question
to
whether or
look
not
at.
you even need to roll them back. I mean, I just, if you've approved them, unless you find a glaring issue with what they're doing, I question whether or not you actually deny them their application to do so. But I think if you offer a product like what y'all are talking about, I would think that the CPAs in the state would be moving towards that product just because y'all are going to be publicizing it, I would think. And I think it's just going to be, I just think we might get ourselves in trouble if we start going and pulling people's.
That's exactly the point I'm getting. I
Yeah,
agree.
I mean,
Yeah.
I agree with you on that.
Okay, so then perhaps, Mr. Chairman, we do need to go ahead and pursue the audit and get some evidence in here, and let's see what actually is out there. I mean, the board approved it initially, but let's see if there's any problematic
Well,
issues that we run across.
And again, I'm just saying if we're talking about pulling everybody else's ability to do it so that TSCPA is our sole one, that's where I would want to know that information. If the option is to continue to let these 18 continue to operate and then add the TSCPA as one, I don't know that it's as necessary. But I may have been mishearing you, but I thought we were talking about pulling the 18.
I do think it's important that you go back and at least review them, and if there are problems, we need to discuss those. I mean, because I do think we have a due diligence issue on that to ensure that what's being provided is current and applicable to what we need. But I think even if it's just reading the rules and answering questions about the rules, that's pretty specific to Tennessee. I don't know how you deny them the ability, after we've already approved it per se, to pull it. Now, I guess we have the right to do what we desire, but I would hate to go that route if it's not necessary. I don't know how y'all feel. I'm obviously not on this committee. I'm sorry I'm speaking so much, but I don't want to see us get ourselves in trouble for pulling somebody and just creating this. I do think with the advertising, with the publication, TSCPA will be pushing out to all the members in the state, and it's going to be an affordable product. It's going to be done in conjunction with the state board and the Tennessee Society. I got to believe most people will move towards that product.
The consumers will take care of
Right.
whether they
Right.
choose to go with the 18 or with the TSCPA.
That's right.
You could put a 5-year statute on the thing and say, we'll leave it open for 5 years and let the TSCPA move forward with what they're doing and put their price on it. Let everybody else put their price on it and see what happens after 5 years. But when you talk about audit of the CPE sponsors, Mark, it may be that you could take a look at maybe half of them or 2/3 of them, but not necessarily do an in-depth evaluation of what they're doing. Just take a look at their course outline or ask them to send us information about what they're currently doing, and let's kind of see where they are in this process as part of the audit part. Instead of really digging into 4 of them, you might want to try to do just something less, but on maybe half of them.
I would suggest more of them as well, because I think what we're trying to get to here is the idea of one consistent product so that everyone's hearing the same message. And I think if you look at more of them, you'll get a better feeling as to whether that objective is being met or not.
I just hate seeing this board reverse decisions that it's previously made and saying, hey, we thought it was good at this point. Now we're saying it's not so good. And I think that's a dangerous path to take. And I do think the market will take care of this, quite frankly. I fully believe that, but I may be wrong.
I have a question. Out of the 20,000 or however many CPAs we have, how many are doing TSCPA versus one of those 18? I mean, I'm kind of like Trey. I feel like the market's going to, if somebody's not any good, they're going to not sign up for that class. And there's going to be a shift to go to the TSCPA, and that may be more natural. But I'm just curious, are most people doing TSCPA versus one of the 18? I mean, is that a pretty small percentage anyway? Or do we have any numbers?
I don't have registration numbers with me. Might potentially be able to get those before tomorrow.
Some of those 18 people offer courses through the TSCPA. When you all offer an ethics class through the TSCPA, don't you use one of those 18 to give the class?
Sometimes, yes.
Yeah.
Those 18 have their own courses that have been approved.
Okay.
So they don't necessarily have to go through the TSCPA. Now, the board staff addressed about 1,500. Is that correct, Karen?
Sorry.
We had about 1,500 attendees that we addressed in the last year. So there are like 10,500 active licensees gay. So out of that number, we did more than 10%, just the board staff.
Well, and I look back at this, I said, we offer this product for free from our board, and we've talked about this in the past and what we charge for licensure and everything under the sun and what value our CPAs receive from this board, whatever you want to call us, in return for their licensing. And so this is one avenue I think you could provide value to your CPA licensees. And I don't know. That's why I'm asking about the fee structure. I'm just curious.
Interest of time, why don't we just continue this discussion tomorrow at the board meeting? Unless somebody's got anything else they'd like to bring up about it. Is that okay? On the agenda, we've got listed there discussion on tax preparation and CPAs working in unregistered firms. Mark, has something come up to cause this to be on the agenda? Have we got a lot of CPAs out there working in unregistered firms?
Well, how do you feel about
I see it.
CPAs working in H&R Block? I mean, we have CPAs who are working in tax preparation firms, and that's our primary issue, especially with tax season coming up. By the next time you all meet, it's going to be after tax season, and this will be gone for another year. But staff needs to know how to pursue this. Can a CPA work in an unregistered accounting firm and provide tax services
Sign as a CPA. Is that correct?
and sign as a CPA. But if they're a CPA and they're not signing as a CPA, is that an issue as well? And in my opinion, it is.
I would point out that in the legal report, there is one recommendation of somebody that works for that prepares returns, does not hold himself out as a CPA, and does not sign the return as a CPA. And I think better a warning or dismiss the complaint. There's no adverse reaction to that.
Have a recommendation from the legal team on this issue? I don't mean to put you on the spot.
I'll go ahead and put her on the spot. She's been working with me for 2 weeks now.
I'm an expert now. The matter that I believe that you're referring to, Mr. Blofus, is a retired CPA that is doing returns for individual families and friends, and it was a limited number. I think when, as Director Crocker pointed out, when you've got CPAs doing massive amounts of returns for H&R Block, brought up with me the other day, I too am concerned. I think that's a different matter from what was presented on the legal report, but quite frankly, I'm just jumping into this now, and I don't want to give you a legal opinion on the issue that Director Crocker has brought up without having been able to research that further. I know that in that limited basis, as presented on the legal report, that was my recommendation.
Number 21.
Yes, sir.
Mark, if an individual works for H&R Block and they're just an employee of H&R Block, but they're a CPA, and they're preparing tax returns and signing those returns on behalf of H&R Block, it seems to me that maybe are you thinking that they ought to be registered as a firm working for H&R Block and signing tax returns?
Now, that's a whole separate issue.
Is it?
Henry, as far, trying to get H&R Block to register.
No, I'm not asking about, I'm not saying H&R Block would register, but the individual, what would be his requirements? Just to register himself, or what are you asking? What does he need to do to resolve the issue here?
Well, see, that's just the issue. In order to offer accounting services, you've got to do them out of a registered accounting firm.
No registered accounting firm.
If H&R Block is not going to be a registered accounting firm, then can the CPA actually work for them and provide those accounting services?
Can a registered accounting firm work for H&R Block? Does that make any sense?
No.
Doesn't?
He's saying if a sole proprietor were to register themselves as a registered accounting firm, then could they provide services to H&R Block? I'm not meaning to
Contracting.
speak on your
Exactly.
behalf.
Contract basis.
Yeah.
Then yes, I don't see a problem there.
That might be your answer right there.
Yeah.
How are these people? Are they W-2 employees, or are they? I wonder
Yes,
how
they are
they
W-2
are.
employees.
And are they actually signing, the CPA signing as a CPA, the tax returns they're preparing, or somebody else at H&R Block signing them? I don't know how the process works.
I think they're probably signing them with their name, but here again, they're a CPA. They've got their certificate on the wall. You know, if you're in a small town like Oliver Springs, Tennessee, and you know that Susie Smith down the street is a CPA and she works at H&R Block, you know, that's kind of where you're going to go to get your taxes done.
Seems like the solution would be that we would have them to register as a firm if they're going to provide services to H&R Block.
And that is a good resolution. I mean, I just need to know how the board wishes to pursue this particular issue, because it's going to come up. It
I
came
think
up
that's
last
your
year.
only option.
Yeah.
I mean, I don't know what else
Yeah.
you're going to do.
Yeah, I can't think of another way to handle it.
And when I write that letter to the CPA, I want to know that the board's behind me when I do that.
Isn't the Joel Sussman email that's on the agenda here, isn't that precisely this issue? that
No,
he's
no,
retired?
no, I don't, no, Joel's not working for H&R Block.
Being told that he can't sign a tax return.
Because he's a retired CPA. He's turned in his license.
But is he holding himself out as a CPA?
Well, he's working, preparing tax returns.
So can he do a tax return for his brother-in-law?
I would think, I don't know. I don't know. I'd think you could do it, I mean, you could do it for your brother-in-law, but, but I don't know.
Did he work for H&R Block?
No, he does not.
The only difference there is because he was a CPA at one time. So I'm not a CPA in
Yeah,
Tennessee.
he was a CPA one time. It's my understanding he's going back into the firm that he retired from and working during tax season preparing tax returns.
So if I'm not a CPA in Tennessee, I could go work in H&R Block?
Yes.
And there's other people that are retired, have retired their license, that are working for CPA firms during tax season. It's just an opportunity for them to pick up a little work if they feel like they can handle it.
Is that okay or wrong?
I believe the way Mark is interpreting is that it's wrong, that they cannot do that.
So they're going to have a lifetime penalty for having been a CPA at one time in their life.
If a non-CPA, they can go do that work, but you have a CPA that cannot go back and do that work. I don't like the logic there.
It seems kind of
There's no
backwards.
logic.
Yeah.
I agree with you. We've kind of worked ourselves into a box there that we
Right.
can't get out of.
Yeah, Mr. Chairman. There's kind of two layers to this. When they're registering for the PTIN, they're saying that they have the credential of CPA. They're attaching it to a Tennessee address, and that information is available under the Freedom of Information Act, so it's public information. So technically,
Holding himself
that's
out as a
holding
CPA.
himself out as a CPA in Tennessee. So that's kind of one thing. And then doing the work under the definition of accountancy in Tennessee out of an unregistered firm, that's the second thing. So it's kind of the two things put together, when they're registering that PTIN, saying they're a CPA and a Tennessee address and performing the work.
That's exactly right. That's exactly right. That's a problem. That's how Joel Sussman and others have been discovered,
Yes.
is through that
PTIN
PTN
directory.
process.
Yeah.
So that applies to people even if they voluntarily give their license up or retire and turn their license in. They can still be tagged that way?
That's what Joel Sussman had done. He had given up his license.
Back on this H&R Block issue, Gabe, do you see an issue? I mean, could this open us up if we went the route that y'all were talking about that they need to register? I guess the question becomes, are we opening ourselves up for other issues of people just not wanting? I mean, are we opening the floodgates for people to become an unregistered firm? I mean, what are the adverse effects of doing that very thing? I don't know the answer to this.
Yeah, I mean, so I don't know that I can fully articulate it now either without thinking about it a little bit, but one of the issues could be that I just thought of is if H&R Block relies upon employing these individuals instead of having them as contractors, then I would assume that if you're going to have an individual register themselves as a firm, they would have to have a contract relationship with H&R Block rather than an employee relationship.
That's why I was asking about the
I think
W-2.
so. I think that would be a potential big hurdle.
Right.
I don't know what H&R Block's position on that would be, whether they want an employee or a contractor or what. Then you've got potential IRS issues about them coming in and saying, well, are you actually an employee or a contractor? And there's issues there. That's the first big flag that I see. In terms of opening the floodgate for other issues, I'm not sure, but I'm also not sure that what we're currently doing right now doesn't do the same thing.
True.
With what we're currently saying, that I, as a non-licensed Tennessee CPA, have no problem. The board has no problem with me going and preparing tax returns at H&R Block. But if I had retired or voluntarily gave my license up to pursue a legal career, for example, and then I go do it to earn extra money, that is an issue. I don't know.
Let me clarify one thing, Gabe. If you close your license, if you voluntarily give it up, then you are no longer a licensee, and then you can go and work in H&R Block all day long. It's if you have a license that is in a status that's retired or inactive,
Okay. That's an important nuance. Okay.
because you still have your license.
You have the ability to reactivate it.
Yes.
Gotcha. Okay. But by not doing anything, we're letting H&R Block have potentially a regulatory advantage over other accounting firms that must go through the permitting process, et cetera.
H&R Block advertises they have CPAs, right?
What do other states do with H&R Block offices? Do they require registration?
They are struggling with H&R Block just like we are.
Just like, okay.
It's a national firm and it's a national problem. The other states are doing their best to regulate as they can.
We're using H&R Block as an example.
example.
Because there are many firms out there like them.
Yeah, I mean,
Yeah, there are lots of tax prep firms. I mean, in the past, when I've had a CPA inform me that they are working at H&R Block, in 2 or 3 instances, I have made them close their license if they want to keep the job. I mean, that's the way that I've interpreted this. If I am wrong, then tell me I'm wrong, and I will send them their licenses back. But that's the best interpretation I can come up with based on the current law.
I think our posture ought to be that the law or the rules say that if you're going to hold yourself out as a CPA, that you need to be employed by a registered firm, right? I mean, I think we just cite the law.
Good point.
Okay.
As
Not
opposed
all-
to giving them the mechanism as to how they do that.
If they want to ask about how to do it, we can offer them thoughts. But
Right.
But let's say there is a CPA that is working at one H&R Block, because obviously not all H&R Block offices have CPAs working there. A lot of them are just individuals that grew up with the taxes. So if one H&R Block office, if there was a CPA and that person said, okay, what do I need to do to get my H&R Block office registered? Do we have a mechanism to help them do that?
well, that's where
I don't think we're asking the H&R Block itself to register as an office to register. We're asking the individual CPA in there to register himself as a sole practitioner.
But then that
As a firm.
becomes
But I'm not
the-
sure H&R Block could register under our
Okay,
rules,
that's what
could
I'm-
they? Because of the ownership issues and,
We've actually had one instance where the H&R Block franchise was purchased by a CPA,
okay.
and the CPA registered the H&R Block franchise
you.
as an accounting firm.
Yeah, but I think the option of the individual registering as a firm and then potentially contracting with H&R Block is a potential solution.
So there's a option for that
A
person to
workaround.
continue, a workaround.
Did we get into the whole W-2 versus 1099 as in contractor versus employee? I mean, I think that's
I don't
pretty-
think,
I don't think that makes any difference.
You don't think that
I don't
matters?
think that's our concern, right? I
Okay.
mean, is our concern, I mean, as I understand this issue, is if you're holding yourself out as a CPA, you need to be working with a registered firm. Well, that solves that issue. How they go about all these other issues.
Right.
Their concern. Yeah. Okay.
We got enough discussion that we can bring it up tomorrow and talk about it some more.
I think so. And tomorrow, if somebody will make a motion to one way or the other on how we should approach this and let me know, then I'll be more than happy to start shooting those letters out. We calls about CPAs working at H&R Block.
This is a board issue and not a legal issue. What is the legal position on the question?
After hearing your discussion, and my opinion would be if they are working as a CPA, receiving compensation for their services, it is different from what you saw in the legal report, an individual doing individual tax returns for friends and family. As Mr. Crocker pointed out, if these are employees of not just H&R Block, but firms that are doing tax preparation and holding themselves out as CPAs, then they have to be working for a registered firm.
So one question, I guess, would be, and this maybe go what Mr. Alexander said earlier, I think it was him, about the contractor versus W-2 piece. I guess my question would be, legally, in our rules, can a firm have anything other than an arm's length contractual relationship with another financial entity that's to prepare their service? In other words, can a firm actually be the employee of a non-licensee to provide these types of services or not? Or does it have to be a contract? I would think it would have to be a contract, but I don't know that for
I wonder if
sure.
the rules get that specific.
I don't know. I mean, I just wonder if there's anything in the rules that deal with that.
I don't think they get that specific, and as Mr. Alexander pointed out earlier, I think that that is getting into contractual issues between individuals that are outside the purview of the board. The board's responsibility is to make sure that if you're doing accounting work, that you are properly licensed and that you are working for a registered firm. Anything outside of that is beyond our scope, I think.
How they're getting compensated really shouldn't be an issue to us.
As a firm or as a firm and a CPA, they're obligated, even as that employee, to abide by all the appropriate ethics issues that they have to, ethics rules that they have to deal with. Even though H&R Block wouldn't necessarily have to do that, or the company that they work for wouldn't necessarily have to abide by those particular policies. Okay, we will bring this up again tomorrow.
Thank you.
Talk about it. Anything else we need to discuss, Mark? Anything else?
Not that I'm aware of, no.
Okay. If not, we'll be adjourned. Thank you.
They needed to be updated. At first, there was some discussion about what the policy statements actually were. And then in reviewing them, I'd like to thank Karen for kindly going through and doing that for us. With that in mind, I'll just open it up for discussion, and then we'll go from there. They are on the iPad if you haven't seen it.
Madam Chairman, I'm not on the committee, but I'd like to comment today, and I will tomorrow, that despite my years on the board, I was unaware that we had these set of policies until recently. And I guess my concern is they're not available on the website, and they do not carry any authority from my understanding. And my question is, why do we, if there are things in here that we need to be following, why don't we put them in our laws and rules rather than out here in a place that's not accessible to the board or to our membership?
I have a follow-up, if that's okay. Is there any reason why these couldn't be posted, if we do decide to continue to have a policy, that it couldn't be posted on the website where it would be accessible? Because I know a lot of the agencies in my practice that I go before, you know, I'll look at the regs, I'll look at the statute, and then I know that there's going to be some sort of policy guidance manual that they're following, and it's been helpful in these last 5 or 6 years. A lot of agencies do publish these where, if you know, you can find them pretty easily. So is there a reason why we couldn't, if we keep them, have them readily available on the website?
No, not to my knowledge. We can certainly put them out there.
I think if we do continue having them, that they should be easily accessible and people can easily see that they exist and be able to access them.
It is kind of nice having them in one place, though, to Mr. Blofus's point. I agree they need to be public record either way, but, you know, if they're good enough for us to put them out there, then why are they not all in one place, so to speak? But that's just
Why are we not having them all in the rules?
yeah. I mean, I agree with you. I'm not disagreeing with
I
anything
wasn't
you're
commenting
saying.
on that point. I was commenting on the, if we keep them, then they
Yeah.
should be out there. I think it's another debate about whether you want to have guidance that maybe comment further on your rules.
So one of the things I did look at, or was kind of trying to figure out, was the difference between the two. Some, I could see a clear further explanation, which I think is what the policy's set up to do, explain further about. So, for example, where it was talking about the right to approve or disapprove. And, you know, in our rule, it's one sentence. In the policy, there's a paragraph kind of behind it. So I can see value in that. I also saw what I thought like confusing. For example, when it talks about the firms, the policy on the firms, which was
Or 4 on the firms? There was no, is that what you're talking about? There was no, like,
so I was actually looking at, number 4 on registered firms, where it says number 2, fictitious firm name shall be reviewed by the executive director and the firm coordinator. And then it says if they don't both acknowledge any firm names, it shall be forwarded to the executive committee for approval, which actually is not what we've been doing.
We don't have an executive committee.
Right. So you know, I'm not sure if that isn't making it more confusing. So I think if we do decide to go with this, we want to be really sure that we're matching exactly, or, you know, referencing and following up. We would have to make sure we're keeping it updated. Just my comments.
I agree with that wholeheartedly.
And there are a couple in here that, you know, where we say the rule clearly states, so there's no reason to have it, you know. So again, thank you for following up with this. And and there's a one on page 8 that talks about number 5, where it says this should be addressed by a rule change. So
Where is that, Charlene?
on page 8 of the number 5 in under registered firms again.
Oh, the comment, yes.
Comment, right.
While you're looking at those, let me bring up a couple of changes that Wendy suggested when we met with them on Monday. If you'll look in the firms, I believe it's Roman numeral number 4. And then look at number 3, where it says peer review is not required of CPA firms that perform only SARS 80 engagements. With SARS 21 coming into effect, and there is early implementation allowed, do we want to delete that and just, I think that perhaps deletion is the way going. Go ahead.
So with previously, SARS 8 referenced management use only financial statements. And the AICPA peer review standards did not require a peer review if that was the highest level of service that a firm performed. So I believe this was created initially to make the state board program that existed prior to 2009 comply with that same, kind of mimic that same requirement. SARS 8 doesn't technically exist any longer. I believe they're just referred to as management use only financial statements. And with SARS 21, there won't even be that anymore. It will be something performed under the preparation standard. The peer review board has an exposure draft out that says they will continue to exclude that similar type engagement from the peer review process. I will tell you that some states don't agree with that and require it in peer review, which is why I think this type of policy was created. Does that help explain it a little bit? But I mean, if you delete it, you're already in the rules accepting the AICPA peer review program and its requirements. You no longer have a program of your own, so to have something like this probably isn't necessary.
Want to talk about number 4 as well? I mean, was that just a deletion all the way around?
And number
And there
4.
again,
Yeah.
Charlene, number 4 needs to go as
Right.
well.
So I think one thing we might want to consider maybe is, do we put this up to the board to discuss whether we want a policy statement? If so, we need to make these changes.
I think we need to be prepared to offer the board a recommendation, because
Okay.
I'm not sure the whole board will want to. We'll have to go through each, and would probably rather the committee do the work, would be my thought, but
Well,
I don't know.
I guess I was thinking more in terms of.
I
do
mean,
we
the
want
overriding, yes.
Right, the
I agree
overriding,
with that.
yeah.
I
So,
just think
but
we need to be prepared if they say, well, yeah, we want to keep them,
Then what would we
what are
do?
we going to do with them?
Okay. Okay. Well. Do we have a recommendation of, I guess, first of all, what are we going to do with them? Does
Well, do we
anyone
need
wanna
to
make a-
discuss these where there's like a question? Can this, like I'm looking at number 5, comment KC8, can this instead be accomplished without opening a complaint? We have some questions here, so I'm not
Right,
sure
okay.
if we needed to just resolve.
But if we're not going to have a policy, do we need
Well,
to go
I
through?
mean,
That's,
it's a chicken and egg thing,
Yeah,
because what,
I guess the question is, just listening to y'all's comments at the beginning, I mean, I think I'm in agreement that, and what Charlene said, you know, if these are basically jumping off of our statutes and our regulations and providing people that are out there guidance on how we're going to do it to keep people from getting into trouble, that are actually trying to do the right thing, then I think they're a good thing. If they're going to, you know, be another source of trying to legislate or dictate and they don't have a basis in the laws and the rules, then they don't need to be there. Like the one that I think Karen pointed out, that non-CPA, the 50%. I mean, that clearly, when I read that before I saw the note, I was like, why is this? I mean, this isn't in a rule or a statute, we don't have this authority. So that needs to be. But if, you know, I think it's important that we go through, and these should be helpful to give people further guidance of what they need to be doing to man the ship, so to speak. But if they're not helpful, then we don't need them. It's just one more layer of something that doesn't do anything. So I know that's not helpful. So I guess I feel like if there's really something important to say, then I think they're worthwhile and they will help.
Mark, do you know how and when these started? Or
I don't have a clue, Bill. They have been here as long as I have. There were some editorial comments in here. Let's see. Original policy approved 2001, 2003. I would assume turn of the century would be about when they were.
for that.
That would be my guess. Oh, well, never mind. Late last century.
These also provide staff with the guidance. Like I'm just looking at like the first. Well, I'm on page 6. Oh, it's the first page that we have about that first one that's saying that a CPA examination applicant that's been convicted of a felony, they must submit additional information to the board. I mean, is that something that's supposed to help staff know how to advise these people, or?
Yes. I mean,
So
that
everybody's-
lets us know that there's nothing in the law and rules that says they have to present additional information. This is just guiding us on how to pursue those applications once they come in.
So staff finds value in the policy.
Yes.
Okay. That's significant. So.
I guess it provides consistency too when you have staffing changeover. There's a clear manual for how to do certain things.
Now, I do agree with Mr. Blofeld. There are some things in here that I think probably need to be made into a rule. But for right now, if we could just revise the policies and then take a look at them later to determine which ones need to transition from policy to rule.
So do we want to make a recommendation about keeping the policy or not keeping the policy?
Well, I think if staff finds value, I would start with keeping the policies, would be my recommendation, and then
Would you like to
do
make
the revisions. I'll make the
motion?
the motion, or was that ever an issue? Do we need to make a motion to keep the policies?
Is it given that we're keeping them?
I mean, you'd need,
Unless you recommend
unless you recommend to get rid of them.
Oh, okay, okay.
I guess.
Okay. So,
So I don't think we need a motion on that. I guess we need to figure out, are there questions in here that need to be answered? And then we need to deal with Wendy's comments on 3 and 4 of 4, right?
right, eliminating number 3 and number 4, and I also would like to add the change that I think should be done on, or at least looking at the number 2 under number 4, because we don't have an executive, the way that's
Okay.
worded. So do we want to just go through it, or we want to make a motion to accept the changes of deletion and then answer the comments? Or?
I think most of them are pretty self-explanatory, aren't they? That why they're getting rid of these things, I'm okay with those. It's these over here where they're asking questions on like page 8. Yeah, under enforcement.
My question for that one is, if the executive director can issue a cease and desist order for someone who's using the word accountant and they're not licensed, then why does it have to go through the whole complaint process if the end result is going to be the executive director issuing a cease and desist order?
Isn't it, just going from the other, the enforcement committee, a lot of people had complaints filed about using the word of accountant, and a matter was opened, and after investigation, it was determined, certain things hadn't happened or had happened, and they took certain action, and then a cease and desist letter was being sent at the end. You're suggesting letting the executive director have the authority on the front end to issue a cease and desist, just writing a letter saying, we hear you're using accountant, please cease, if you're doing so, please cease and desist doing so at once?
I suppose so. I think that could be the first step, and then if the person refuses to do that,
Then a complaint is open.
complaint can be opened.
Yeah, it's like you're getting notified. If you weren't aware of the rule, here's the rule. If you don't stop, a complaint will be opened against you.
I'm currently doing it under, with different verbiage, with less authority, of course, saying, hey, you appear to be doing this. This is what the rules say, just so you know, kind of language. And then I'll follow up. And then if not, then I'll present it, I'll file a complaint.
You're not following this policy.
But I think if we do receive a complaint from a member of the public, then we have to pursue it as a.
Maybe we just need to reword this to say, if it's found, we can address it with a letter, and if the letter, unless it comes from the public.
I just think there are people who don't know that the word accountant is a protected term in Tennessee, and I think it would be easier to inform them of them, give them an opportunity to stop.
That might cut down on our complaints.
But a kind of an informative, like you're giving them the information. It's not a cease and desist orders, but it's a,
And Mark could
Yeah.
report on that, I would
Yeah.
assume, to y'all, that committee, to the enforcement committee, how many of those he's issued or,
Sure.
right? I mean,
yeah, I defer to legal if that's possible.
By having him send the letter, or by you issuing a cease and desist order?
I'd be issuing a cease and desist
No,
order.
you have that, you can be delegated that authority by the board to do that. And it appears that that has already happened, that they've given you that authority. I know from my experience in other boards that the executive director does that on a regular basis, so I don't think it would be any different here. And I agree that by doing that, you would cut down on a lot of complaints being opened, because I think almost half the legal report is, you did this, stop, and they said, oh, okay, and so then it's closed with a letter of warning or dismissed, so.
So is that what we've done here by number one? The board has already, through this policy, delegated the authority?
It looks like it. It's just that in the past, my legal counsel has advised me that they would prefer that the cease and desist letters come from legal rather than from the board. Apparently, that pendulum is shifting from what I'm hearing, so.
That may have been a personal preference, and I will check on that, but I know that the other board that I advise, the executive director can do his own cease and desist, so.
I'd be more than happy to do that.
I see no problems with granting you that authority, because I do think that's a logical first step, is saying, you're in violation of the rules, you need to stop what you're doing. And if you don't do that, then you step up to the complaint phase. I don't know. I'm not an attorney, so
So basically, we've already done it. You just need to start following this policy.
That's right.
Yes.
Okay.
Well, is the policy, oh, yeah, that's right, okay.
Have you, you've reviewed these policies. What is your reaction to them from your other experiences? Are they appropriate? Are they well-drafted?
I have not been able to go in depth with them as I would prefer before I advise you on that. I will say that in the little bit that I have been able to do reviewing before today, and in my experience again with the other board, that they actually go further than what I am used to, but that they are well drafted. They do seem to be clear on what is expected. I am concerned hearing today, as you pointed out earlier, that they're not on the website. They're not easily accessible. I think that needs to be addressed immediately once they are approved, that they do need to go on the website, because this is something that would help your licensees a great deal, I think. But they do seem to be well drafted.
Can I go ahead and make a motion then? I will make a motion that we adopt the changes as outlined in the document that are already here. In addition to that, that under section 4, you're gonna have to stop me if I mess this up, 3 and 4 be removed, right?
Right.
And then you had a change on, was it 2?
Number 2,
That we get rid of that one as well,
well, not get rid of it,
or get
but
rid of the executive,
change that last sentence to say that it's forwarded to the state board or the, with the appropriate committee
okay.
rather than the executive committee.
With the change that it be forwarded to the appropriate committee for approval.
Committee can't approve
Well,
the
to,
Well-
ultimate authority.
to the board.
To the board, then. Let's change
However
that to the board.
Yeah, to the board, okay.
Do I need to restate that? I don't know if I can.
We've got it.
Okay.
I'll second it. I thought it was a good motion.
Yeah.
Point of question on page 9. Does the Tennessee Department of Human Services still even exist? And is $5 enough fee based on current standards to reinstate? I think that's Department of Children's Services or today, but I don't know. I guess that goes back to legal. If we're going to correct it, that's.
Let's correct that one, too.
And that's housekeeping.
Right. So I'll amend my motion to have legal at least verify the correct name on page 9. Is that number 7?
It will be number 5 if we accept those other changes.
Number 5, after the changes, that we get the correct titling of the agencies involved in the fees.
Can I ask one other, is that appropriate for me to ask a question? On the one, at the top of this page, it's number 1. The last sentence talks about how that you're gonna send the minutes out to the board members for review at least 2 weeks before the board meeting. Do we meet?
I'm trying to think when Karen sent those documents.
I just wondered if it would be better to
Maybe
say
not give a
reasonable
specific,
time.
yeah,
Yeah, can we just get rid of that?
get rid of the date.
Or just say, not, well, get just prior to the meeting.
Just say prior to
Yeah.
the meeting, that's good.
Yeah, that's real good.
Change that to prior. Are you making notes too, Karen? Good.
All right, so where are we? You need a re-second anything? I don't know what we've changed.
Your motion said we're number 5 on the human resources. We're going to do that. We're
Yep.
going to make the change to number 1 on that same page.
Yep,
I'll second the motion.
okay.
Right, all in favor?
Aye.
It passes.
Karen, could you make the revisions before tomorrow and give us another red line copy?
That'd be great. Thank you. All right. Do we have other,
And I guess tomorrow at the board meeting, we'll just recommend that do we need to approve that they get put on the website? Just get them out there. It's all public record anyways, I guess. Should be.
I'm sure they'll be heavily read.
We need to put a counter on it. Can we do that?
Are we having legal looking at these a little more close? Are we done with these now, or are we
I
gonna
think we're gonna have to
further-
revisit, because I
Good.
think
Right.
what'll have to happen is that y'all will need to then come back, and maybe with Mark's help or Karen, whoever needs to be involved, we need to determine if any of these actually need to be put back into rules.
right, we have at least one that we know we need to look at for a rule change. So.
Yes, ma'am.
Okay.
I do have one question, Madam Chairman. Do you want Appendix A put on the website as well, the guidelines for disciplinary action?
Is this still accurate? That was the question I had. I mean, is this still what we do? I mean, is this still up to date?
Not close? Well, then
Close?
really-
Well, then we
that
certainly
definitely
wouldn't
needs to
want
be
to put it.
updated.
Do,
I would suggest, it's just a guideline, and the enforcement committee or the board could follow it or not follow it. So I probably wouldn't
not
publish it.
post it.
Yeah.
I would say not to post it. Can
Thank
we?
you.
I mean, you
should
pull it
we
out of
make
the
a-
rules,
Do we need to make
or out of the policies?
right, well,
Or do
just
you
pull
leave
it,
Well, if you're putting policies out,
if we put the policy out, we have to put it out there, I would think, right?
I would think so.
But we removed it from the policy, so maybe today we need to make a motion to remove Appendix A from the policy.
Policy statement. Yeah, the policy, sorry, the policies.
And then we can revisit if we would want to add the correct information back in, or whether we just leave it out.
We have guidelines posted in our rules, don't we? Yes.
The statute actually says it's $1,000 per violation per day. So yes, these are simply guidelines that have been used by the enforcement committee.
I'll make a motion that we pull Appendix A out of the policies.
Second it?
All in favor?
Aye.
All right, we're done.
Post everything else, once it's approved by the board tomorrow.
Have a,
Well, I guess it has to be posted, never mind. I'm thinking if we're still gonna keep altering them, we're gonna put them out, and then we're gonna have to pull them back and then put them back on. But we're public law, so I mean,
This should
I think it
date-
needs to be out
We should just put
there.
a date at the bottom as, as of,
Revised.
revised as of this date, and then it'll be clear to whoever's looking at them that there's a newer version.
We will.
that's all? Do I need to take a, no, I can just adjourn.
I think you probably need to have a motion to adjourn.
I need a motion to adjourn.
So moved.
All right, then we adjourn. Second? Okay, great.
adjourned. I'm done. I'm leaving. Fine, how are you?
Except Gabe Roberts, did he have to leave, I guess?
Yes, sir.
Okay. Our agenda for today, we've got two items. One, first item is review the complaint statistics. And Mark, is that a separate report we have, or I have not?
That is on your iPads under status of open complaints.
Correct. Don, do you want to run through this for us or make some comments?
Be glad to, Mr. Chairman. This is your standard fare of open complaints with the history going back to, this is basically a calendar year report. If you look back over the last 3 meetings and then today. The only thing I have of real interest is that we had quite a jump in cases last quarter. If you look at the legal number that we're looking at for today at 55, and then you look at the legal report, you'll see there are 45 cases that are going to be heard. Are we up to 47, 48 now? Are we up to 50? Which means that our council only has about 5 cases left, so I guess we'll have to get busy and find her something to do.
Oh, that's okay.
So I feel like we're making progress. We got a little backed up. We've gone through a lot of cases. As I think I told you last time, a lot of this has been due to the examination of the PTIN listing that Ray and I started. And I did want to note that we have had, based on these complaints, and we've had at least 11 new firms that have joined us due to the incorporation of the PTI listing and follow-up. So we're getting the firm numbers up as well.
Good.
A question, just, I think it's something we've discussed at a previous meeting, was sharing information with the TSCP. I don't think she must have gone. But we were talking about people that had filled out applications here for firm permits and whether they do a test work or not. Are we sharing that information now for peer review with the society?
Karen, I'll let you address that, because yes, we are. We're in
Okay.
communication with them.
When we receive a new firm permit or a renewal, and the firm has indicated they do a test, I verify with Wendy
Whether they're enrolled
if
in
they
the
have
peer review
enrolled.
program. Okay. Thank you.
Okay, thanks, Don. Appreciate your comments. You should have, I believe, a paper copy of the legal report in front of you there. I know I got an email copy of this about 2 minutes before I shut my computer off to get in the car and drive over here. So I did have time to read through it while I was listening to the other committee meetings. But has anybody not had a chance to see this before or read through it?
I've read through it. Yes, sir.
Don? Everybody, you okay? All right, that may help us move a little faster then. Just kind of to summarize this, and it really helps that these cases are organized according to the, I guess, recommended action that we're going to be taking. I think that was a suggestion from our board chairman, and it worked very well last time to kind of get things in focus. But if you just look at the top of page 1 there, just a summary, we've got civil penalties authorized is the number is 10. The amount of civil penalties is $14,750. Consent orders for suspension, surrender, or revocation is 10. Placement of complaints into litigation monitoring status is none. Cease and desist letters 2, letters of warning 21, and dismissals 15. So hopefully we can move through those last 2 categories very quickly. Again, recommended dismissals are cases number 1 through 15. I have read through those. They seem pretty self-explanatory and straightforward. I guess would ask, is there any specific items anybody wants to discuss or any comments from any of the cases? And if not, then maybe we can go ahead and get a motion to approve the recommended action on those.
Make a motion to accept the recommended action on items 1 through 15.
Second that.
Okay, got a motion and a second. Is there any further discussion? Okay, all in favor say aye.
Aye.
Any opposed? Okay. Items 16 and 17 are recommended cease and desist letters. Again, reading through them, I thought they were pretty straightforward. I did not have any questions, but does anyone on the committee have anything specific they would like to comment on or ask a question about? Okay, hearing no comments, could I get a motion regarding items number 16 and 17?
Moved.
Second?
Second?
Okay, all in favor say aye.
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 Opposed? Okay. All right, going to the next page, page 5, we've got items 18 through 38. Again, I read through those, did not really questions or thoughts. I think they're pretty straightforward, but again, are there any comments or questions on any of these? Don, you look like you're about ready to say something.
I'd move for approval of items through 38 there that you'd mentioned.
Got a motion?
Second.
Okay, any further discussion on items 18 through 38? Okay, all in favor of the motion, say aye.
Aye.
Any opposed? Okay, we're on page 9, and these are the recommended consent orders, and I guess my thought is we ought to just take these one at a time. They are more significant, and I did have some questions on some of these, but I thought we might just take them one at a time and talk about them. Item number 39, got to do with respondent failing to meet CPE requirements. I think the respondent ultimately completed the CPE, however, it failed to timely respond to the complaint as required by law, and there's a recommendation for formal hearing for the revocation of the respondent's CPA license with the authority to settle via consent order and a $1,000 civil penalty. Does anybody have any questions on this?
How did we come up with the suggested monetary penalty in this case?
Mark or the investigator, who?
I would defer to the investigator. I think that they have a better grip of the facts as we sit here before us. I do not have the investigative reports with me, so.
Chairman, we arrived at the $1,000 because this was not the first time that they had been in trouble for, not necessarily an audit, but other procedural things in their firm. Been fined before.
Okay. Thank you.
That would be 39 and 40 as well, or just 39?
40 is mine too. Well, if that was the same thing, it probably was. I can't recall the details of the second one. But that's generally why they jump from 500 to 1,000 is because they've been in trouble before or have had some kind of complaint before, just moving up the line. And penalty? I mean, if they didn't hear it the first time at 500, maybe they'll hear it at 1,000.
Could I just maybe ask a question here? When it says recommendation for formal hearing for the revocation of the license, I mean, this is a person that's now met the CPE requirements. What does that really mean when we say we're recommending for a hearing? Because there's no expectation of that. We would enter into a consent order that would.
Yes, sir. The wording is such that it authorizes me to give them a consent order and an opportunity to settle for payment, of the $1,000. That triggers either the settlement or some back and forth where we can discuss, a payment plan or things like that in order to resolve the issue. If the respondent just does not want to do that, then it's referred over to litigation, and there are penalties all the way up to formal revocation that can happen after a hearing.
Are there any other questions or comments on this one? Vic, does that answer your
Yes, sir,
question?
it does.
Okay.
Move for approval of 39.
Okay, got a motion.
Second.
All in favor say aye.
Aye.
Item 40, this is essentially the same issue, the same recommendation. Again, the $1,000 fine here, is it a similar kind of situation on that?
Best of my knowledge, I believe it is a similar situation.
Excuse me.
Okay, we'll have a motion on number 40.
Move to approve.
Need a sec? Okay, all in favor say aye.
Aye.
41, again, it's on CPE requirements. This is a situation where the respondent is still lacking some hours. And again, a recommendation for formal hearing with authority to settle with a consent order on payment of a civil penalty of $250, but also with a stipulation they have to meet the appropriate CPE requirements. I assume the penalty here of $250 is maybe because this is a first-time situation with this one.
That's my recollection, yes, sir.
There is one other mitigating factor in this. This particular CPA is unemployed at this time, which makes it economic stress. So I felt that was that, and no history of any kind of disciplinary action.
Questions or comments on this one? All right, let's have a motion.
So moved.
Okay,
Second.
second. All in favor, say aye.
Aye.
Okay. 42, the complaint alleges that the respondent failed to comply with an audit of his CPE requirements. Revealed that after the complaint was opened, the respondent submitted a request that his license be made inactive, but in all other respects has failed to respond to the complaint. The recommendation is for formal hearing, for the revocation of the license with authority to settle with a consent order upon the respondent's payment of a civil penalty in the amount of $500. Respondent shall also be required to submit proof of the completion of the required CPE hours. I guess the recommendation here is because he's still wanting to keep his license, just wanting to move to an inactive status. And here he's failed to meet the CPE requirements during a period of time when he was active. Okay.
Yes.
Any questions or comments on this one? Made a motion to approve.
So move.
Second.
All in favor say aye.
Aye.
Number 43.
Again, the question on the amount of the penalty.
Penalty here is $4,000 at, guess,
Sure.
any.
Mr. Alexander, the reason for that, I remember this one, the reason for that amount of penalty is that the respondent essentially admitted that he had been practicing, although on a very limited basis, but for at least 4 years. So it was $1,000 for each year that he had been practicing without a license, and that's also why the consent order requires that he get the reciprocal license here in Tennessee.
Does he have any prior history with this board?
I don't recall so, no, sir.
Questions on this one? Pardon? So this is one that was discovered through that process. Okay, any further comments or questions? Do we have a motion to approve?
Moved.
Second? All in favor say aye. Number 44, let me just let you read that and I'll read it too. Questions on number 44?
Move to approve.
Second? Must be a question somewhere.
There is. Director Crocker just pointed out that the recommendation was a formal hearing for the revocation of the Tennessee firm permit. However, the respondent, as noted in the description, does not
Non-licensee.
does not have a license. So
Yeah,
that
that's
would
what
be-
I was trying to.
Yeah, that would be incorrect. The recommendation would be authority to settle via consent order upon payment of a $500 civil penalty by the respondent. If we could just strike out formal hearing for the revocation of permit.
Basically, if they don't pay it, then our only other option is turn it over to someone outside of this board, right?
Courts, isn't it?
Yeah.
Well, it would then go to a formal hearing. You all could increase the amount of the penalty. If they didn't pay the penalty, then it would go up to the courts and the Attorney General's office to enforce.
How we can I thought we couldn't take them to a formal hearing if they're not a licensee of this board.
License activity, you can, absolutely.
Recommendation would be leaving formal hearing in
Yes, sir.
and then striking for the revocation of the respondent's Tennessee firm permit with,
Sure.
and then with the authority to settle consent for 500.
Yes, sir.
Okay. I'd amend
Okay.
my motion.
Can I ask a question? Is the difference of this one and some other previous ones where they used accounting is because he would, or the respondent wouldn't give an affidavit?
They were given an opportunity to comply and respond through their attorney, actually told the investigator that, I think that they would provide that information, and then just ignored him. And it required the investigator having to go back out there and, as it stated, do a drive-by just to make sure that they were in compliance. Yes, ma'am.
Have a motion. I second.
Okay, all in favor, say aye.
Aye.
Okay. Number 45, we'll read that one.
And how do we arrive at the penalty on this one?
This respondent does have a previous history, not just with failure to renew, but I think he also had some other complaints that had been lodged against him before and civil penalties that he's had to pay before. And as out before, if they're not going to pay or comply after 1,000 or 2,000, let's up the ante a little bit. So that
Do we know what the last civil penalty amount was that we assessed to it? No.
500.
I had the same question about the size of the penalty, but again, if you've got somebody that's just totally ignoring, the rules and regulation law, I mean, they need to be penalized for that, so. Any other comments on this one? Ruth,
So moved.
second?
Second.
All in favor, say aye.
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 Number 46.
Do we accept?
Second.
All in favor, say aye. Aye. Any opposed? Number 47.
Move that we accept.
Second.
Motion is second. I just wanted to ask, is this another one we picked up through the TPIN process, or?
Yes. Yeah.
I got a motion and a second. All in favor, say aye.
Aye.
Okay. 48.
Is this a first-time offense on 48?
Thoughts that the $1,000 may be too much, Vic, or?
A little high for a first-time offense if we've got agreement that she's going to comply.
Thoughts on that? I agree with you. I would, any comments from legal or the investigators on the amount of the penalty here?
The only aggravating circumstance that I can remember from the report was that she had I believe it was she had a taxes, or she had a 1099 from 2013 where she had made practicing, and so I think it was more of an ongoing issue. But if there's any other factors that I'm leaving out, I don't.
It was an ongoing issue, and she was unavailable for any kind of interview. So, might not be
She wouldn't
enough.
cooperate with the board, is that what you're saying? With the investigators?
She left the country.
Available by telephone? Telephone with her.
I got some communication by email. That's all I had gotten from her. I was first told she was going to be back in February. And then she told me in the last.
Okay, Vic, I mean, that, I guess, $1,000 penalty, though.
That's fine.
Yeah. Any other questions or comments on this one? Okay, motion to approve.
Second.
Okay, all in favor, say aye.
Aye. And we had some other privilege tax failures that had a different disposition in the same report. And so I was curious why this particular failure because I mean, it says that he failed to respond in a timely manner, so maybe that's what it is. But the respondent's now paid all past due privilege tax obligations, including interest and penalties. And then back here, you know, some of these prior ones, we had people who had not paid privilege tax, but then they paid it, and we didn't hit them with a penalty. So I was just curious why we're assessing a penalty here.
This particular respondent has a history with the board in regard to disciplinary actions, and that's the reason for the amount of the penalty, Mr. Alexander.
Thank you.
Okay, any other questions on number 49?
Move to approve.
Got a motion and a second. All in favor say aye.
Aye.
Number 50.
Motion to approve.
Second.
All in favor say aye.
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 Okay. That concludes everything I see on the agenda. Is there anything else?
Motion to adjourn.
All right,
Second.
motion. Second. Second. All right, we're adjourned.
Fiscal 14 financial results. Mark, I presume that that is the schedule that came from the,
Yes, sir.
that was sent to the board ahead of time. Mark, do you have any observations? This is finalized after all the cost backs have come through.
Yes, and if you will note down there at the very bottom, out of the reserve balance, they're taking $70,464 from our reserve account for core expenses. That's for the new database that's coming in. I believe Mr. Giannini is going to talk to you all about that tomorrow. That is not a one-time expense, as I think it was explained to us at the last meeting. It will be a continuing expense. It won't be as much as $70,000, but there will be additional money coming out of the reserve fund for the core system. Says that tomorrow. Don't be shocked.
What, I'm sorry, what did you say that was? It was
It's the
computer
new
expense?
database licensing system they're putting in.
Database licensing system.
Software that they're using at the
Software.
state level.
The current system is RBS. It's Regulatory Board System. Henry, it was put in 1993, and they've kind of cobbled it together and made repairs to it for 21 years now, 22 years. And with online licensing, RBS simply is not functional. It can't run reports for us that we need.
It's something that you all use in your office?
Oh, yes, yes.
Okay.
All regulatory boards use it, so it's I think the total cost is like $2.8 million.
Same software, but all the regulatory boards
Yes,
use it for themselves? Okay.
and this is just our portion of the expense.
What if we didn't have a reserve?
We'd be in trouble.
What would they do?
I mean,
kick
I'm
us
not sure
out?
how the other boards that don't have much of a reserve are paying for it.
I'm wondering if we're getting a disproportionate portion of that bill, just due to the fact that we have.
I don't believe you are. I've already heard Commissioner Giannini present to one of the other boards that I am assigned to, and it's based on the number of licensees. So the smaller boards have a smaller portion. I think the Motor V board, it was over $100,000, if not more. And it's being spread out over 3 years, so while it is a continuing cost, they know exactly how long it's going to be in order to pay for it. So as for a board that doesn't have a reserve, I don't know.
Is this 210,000? Is that, you say 3 years, we just paid 70? Does that
No,
mean-
my conversations with the staff earlier this week indicated that 70,000 was the biggest hit, and then you're talking about decreasing amounts over the next couple of years. You know, I don't think our amount's going to be $210,000. I think you're talking maybe 150 total over 3 years.
why isn't this being charged to operations rather than to the reserve? Or that's just what was decided at the commissioner level?
Well, it was decided at the commissioner level, yes, we didn't have any choice in it. But also, Bill, if you charge that to operating accounts, it would run many of the boards into a deficit balance, and that just can't happen.
But the bottom line for fiscal 14, we had another surplus again of, and this time it was $109,000. So
When did the reduced fees go into place?
Reduced fees went into place this year.
This year.
Trey. So what you're seeing here is the $120 fee.
we also have any other questions regarding fiscal 14? If not, we'll go on. The year-to-date results for fiscal 15, Mark?
Are they on here? Or are they?
Yeah, they were sent to us. It's all under financial information.
I see it, okay. Thank you.
Okay, what you have here is a spreadsheet showing operating results, and we have FY13 actual, FY14 actual, FY14 budget, FY15 budget, and FY16 budget. And then the last couple of columns are year-to-date actuals, and the only numbers I've got are through November of 2014. So you have November of FY15 and November of FY14 there for you to compare. There are really no surprises here as far as our expenses go. Everything looks to be pretty much in line. We've got the hit on our supplies and furniture. If you look down there, year-to-date actual, November FY15. This year we had an expense of $5,366 as opposed to $327 for last year. The bulk of that is what we had to pay for reconfiguring the office. When the initial build-in was done, we were charged for all of that. Well, they decided that they needed we needed to reconfigure part of it, so administration got hit and we got hit, and most of that is our cost for reconfiguring the desks, if you will. I don't have $5,000 worth of paper upstairs, I can assure you. Other than that, I think that everything, like I said, is pretty much in line. Through November, we had revenues of $394,713. In December alone, we had receipts of through the online system of over $450,000. So I think we're going to track online as far as our revenues go for the end of the year. But just to let you know, that's where we are. I do think we'll come out with a surplus. It's going to be a lot tighter than it has been in years past, but by golly, we'll do it. Anybody have any questions?
No questions. We'll move on to travel. Ed? Mark has added, in his case, the number of days that he's out of the office regarding each of these expenses, which is helpful. Do you have any other comments regarding them, Mark?
No, I don't think so, Mr. Bloffice. I would add that on mine, I think there were 23 days out of office for the period. Almost 10 of those were for the board meeting at NASBA and the annual meeting at NASBA. Clearly, I'm not on the Executive Directors Committee as the liaison anymore. I'm not the chair. So that number of days will decrease because I won't be traveling for the NASBA board meetings.
My recollection, in the past, you gave us a schedule of the travel that you expected to do in the next quarter.
No, sir, I haven't done that in the past
Okay.
because I really can't predict it because requests for speakers come in sometimes last minute.
At NASBA or TSCPA or the...
That'll be my executive director's report.
Okay. Comments regarding the investigators' travel? And what is Nashville office? What does that mean?
I have to come to town for, well, obviously to turn in reports and things, but also for complaint meetings, board meetings. Anytime I'm in Nashville, I charge it to Nashville office.
And if you're not on an investigation, you're working from home?
Yes, sir.
So, full-time?
7.5 hours a day,
Okay,
unless I'm on the road.
okay.
Then it's more, yes.
Questions regarding any of the travel? Next item is discussion of complaints regarding against national firms.
I don't think you have anything on your iPad regarding this. This is going to be a theoretical, hypothetical discussion only, because here again, I think we need to kind of set some parameters. Let me give you a situation. You have Mark Crocker accounting firm that provides accounting services to citizens of the state of Tennessee. It's a national firm. Are we going to try to make them licensed, or are we going to just let it go and not worry about it? I mean, let's take Robert Half as an example. Robert Half Accounting. I mean, what do we do with that? They are using the term accounting. They're not a registered accounting firm. They're in violation of our state law. Do we want to get into quarreling with national firms over that?
To the local practitioner that uses accounting. So why wouldn't we?
That's my position, Bill. I mean, I think we should. I just want you all to be aware that it's going to be out there. If we're going to do it, then here again, I want the board behind me when I send those letters out.
What do we do on the big regionals?
In what regard?
I mean, do we ask them to license? You're saying, are you saying all national type firms,
Yes.
not just Big Four?
Yes.
Really beyond the big four. All the big four are licensed,
Are
or
licensed,
the regionals
yeah.
are all licensed.
They are licensed?
Yeah.
Yeah.
Okay. So you're talking about the regionals?
Yes, the regionals. Robert Half accounting firm. I mean, they're using the term
Are
accounting.
you talking about Robert Half, the
Yeah.
search firm?
Yes.
They have the account temps is what I believe. Isn't that what, is it Robert Half's account temps?
Yes, I think so.
I hadn't even ever thought about that one, but they're providing CPAs from somewhere to work.
Well, I think we need to get into some discussion with them to get them into compliance as much as we can. Do you want to say, did I hear you say something? No? Okay. It's an issue because we need to get them into compliance some way or the other. That's my point of view. Or we need to look at the statute and determine whether or not we want to pursue keeping our terminology in regard to not allowing the use of accountant or accounting.
Robert Half, the only firm you're thinking of?
They're the ones that are coming to mind because I've already had some correspondence with them. And before I pursue it, I want to be sure that I've got the board's support.
You're not talking about like the true accounting firms. You're talking about people that are kind of on the periphery.
Yes. The true accounting firms are going to be in compliance.
They're going to be in compliance. That's
Yeah.
right. Okay.
It's the ones that are on the periphery that are using the terminology, and perhaps they don't qualify for firm registration because they're not 51% owned by CPAs. Then what do? Do we make them change their name for practice in the state of Tennessee? what's our solution here? Because the smaller firms are looking to me and saying, well, they're being allowed to do it. Why are you penalizing us? And I think it's a fair question.
Right.
Is the concern there the word accountant that's in their name?
Yes.
Account,
Well, not necessarily accountants. Let's concentrate on Robert Half Accounting.
is there a company called Robert Half Accounting?
It's something in accounting. It's Robert Half. What's the name of it? Finance and Accounting. That's it.
Finance and accounting.
Yeah.
What, do other states have such a restrictive application of accountant as Tennessee does?
Some do, and Bill, I haven't done any research on that. I can certainly do that if you all want me to, but I haven't to this point. I'd say it's 50-50.
So
But I don't
has
know what
anybody
the-
else taken on Robert Half over this issue?
Not to my knowledge.
Not necessarily saying you want to take them on, you're just saying you want to engage in some discussions with them to see where they are.
Have to see if we can get some compliance or if we need to take a serious look at our law and rules.
Appropriate.
Not so sure they're breaking any rules.
So, what I hear you say, you want the firms or the board's endorsement to pursue the matter on a discussion basis.
Yes.
That approach?
I endorse it.
Yeah, okay.
I do too.
Very good, but let us know before you start to sue them.
Okay. We'll let you know before the legal hits the fan.
And I have a couple of things that are not on the agenda, but as I understand it, Edwin Osborne has filed suit against the board.
He appealed the ruling that was made at the hearing last year. It went up to Chancery Court. His appeal of that ruling was dismissed last month. He has 30 days to file an appeal of the dismissal. I'm fairly certain he will, just based on what I've heard anyway about prior behavior.
Definitely filing.
Well, it'll go from there. Right now, though, the case is dismissed, which means that the ruling that was made after the hearing stands.
We'll hear more later.
I'm sure that we will hear more later from Mr. Osborne. Yes, sir.
Then you were going to comment tomorrow about the state starting a performance audit on the state board.
Yes, if you all will remember, we are due for sunset on June 30th, 2016. I received correspondence a little bit earlier this month indicating that the performance review for that sunset audit was beginning. We actually have with us today Mr. Chris Lloyd from the Comptroller's Office, who's going to be part of that review team. So yes, the performance review is beginning, and we look forward to it.
How'd we do today? Okay.
He was making sure we actually meet.
Whether we earn our $50.
Yeah.
There you go.
Fictional names. How many times do we need to have this come up?
Well, it's just a pain, Bill. It's just pain. The licensing committee has the white paper on fictitious firm names, so I think that.
And based upon what I heard the licensing committee say that they wanted to do was to take this under deliberation, right?
Yes.
And you've given us information about the AICPA, or who did the?
AICPA, NASBA.
Yeah, CPA.
Yeah,
Yeah.
right, NASBA. And then information regarding what's done in other states.
Yes.
So it's a matter under deliberation further?
Yes, sir.
And that's what the committee basically said, to defer other action until we can.
Works for me.
Are there other matters to come before the executive committee? Mark, do you have anything that you'd like to review with us?
No, I will let you know that we are currently going under, doing our interim personnel evaluations. Under the new system, we do them 3 times a year, once every 4 months. Our requirement was to have them in by close of business tomorrow. So ours are done. They're out there for review and approval. So we're in compliance as far as departmental regulations go on employee performance.
I had one thing to bring up. Are we?
Follow up on that. If somebody gets a good rating and somebody gets a mediocre rating and somebody gets a deficient rating, how does that impact them from a compensation standpoint? Or
The theory that that is behind the whole process is that if you have an outstanding employee, they should get a compensation bump. As you all know, that has not happened for the last several years. Hopefully, there will be some raises awarded to appropriate employees in the next fiscal year.
what is the status that when the budget was submitted, we approved a 2% increase outside of the regulatory board area, that there was no increases were to be authorized or budgeted? What is it? Is that still the case?
That is still the case, yes. As far as I know, there will be no raises this year for state employees.
For the state and for the regulatory boards?
Correct. We are part of the state employee system.
Okay. Because I thought that the governor's mandate of that was supposed to reduce budgets by a certain percent, include no compensation adjustments, and that's still the case. I didn't know that that applied to the regulatory boards.
Yes, the 7% reduction applies to regulatory boards. It did not apply to us individually as a board because our stuff is maintained so separately. But we can't give raises to our employees without approval by the governor.
But we nonetheless put it in the budget. Okay.
Just on the off chance, Bill, that there's something that comes down the pike that tells me I can give my employees a raise.
Other questions?
I had an issue on my reappointment paperwork. I was just curious on y'all's.
Didn't you get a bonus?
No, I did not get what I asked for. But there's a Tennessee ethics form that I had to fill out, which all of us probably filled out, but it asked about contracts with the state of Tennessee. And we do several governmental audits for the state, and you enter into contracts, but you don't really get paid by the state for any of those contracts. I don't know if any of y'all do y'all do any of that work, Henry, or?
No, we don't.
Don't, you don't?
No.
Okay.
Deliberately.
I ended up putting all those contracts, and I had to go into the reporting system and list out 20, 25 contracts, but put zeros in for, I'm just sure, I just am curious if anybody else on the board is, if we're all being consistent, one, with that, but I don't know. I just
I'll check with Casey. I think they
ended up dealing with Chris Whitaker before he left about what to do with that, and then I thought, well, I better just list it.
Yeah, I hadn't thought of that being a case, but I could.
Just didn't know how to answer
That's
it.
a question.
Yeah.
I mean, you had to answer the questions.
Right.
I know Casey's firm in the past has done some of that work.
Okay.
in check.
I'm sure Vic, I would imagine Kraft does some of that. Okay.
Very good. If there are no other matters to come before the committee, we stand adjourned.
Thank you.
Johnson, see you straight now.
I'll keep it up.
Getting ready for that big football game?
Yeah. When are they playing that game?